Let's talk about mediation and our mediation template. So mediation, most cases go to mediation now, and it's a great way to resolve your case. But of course, you want to be super prepared. So our template's going to help you with that. Let's go through the template. So we have at the beginning, you can assign someone to confirm if the court requires mediation. And sometimes we don't want to go to mediation, or our client doesn't. And it helps if you know, well, the judge is going to make you go anyway. So it'd be helpful information to have. Also, confirm if a scheduling order has a mediation deadline. Sometimes courts require you to mediate by a certain date, and you don't want to let that sneak up on you. Then we have how to choose a mediator. And the template allows you to list mediators that you like, so that anyone in your office when scheduling can go straight to that list, and you always have your mediation list. And I have here several of the mediators that I use and like and think are strong. But I'll tell you, in selecting a mediator, sometimes people feel strongly that they should select. I am always happy for the other lawyer to pick the mediator that they prefer, because the mediator is not a decision maker, and I know that I can stand strong, and the mediator is not going to persuade me to do something that I'm not going to do. But if the other side has confidence in that mediator, and the mediator might have some persuasion over them, great. Let's go with the one they like. So don't get hung up on it has to be the mediator of your choosing, and counsel your client the same way. If some mediator is going to help us to get this settled on the other side, great. Pick the one they like, and it's a good way to get exposed to other mediators. Okay, so I like to have a mediator notebook. I like to have one for the mediator and one for myself. And this lays out what I like to have in my notebook, and it helps because I can just assign it to staff. So I like to have an inventory and appraisement if it's a divorce and if that's at issue, so that I know what we're dividing. I like to have the latest pleadings, because maybe during the day you're going to, the mediator would like to see what's been pled, but maybe during the day that's going to come up. And you might even, if it doesn't look like it's going to be settling, be thinking about trial preparation. So do you need to amend your pleadings? You might be looking at that during the day. You know, there's a lot of downtime in mediation. So I like to have the latest pleadings from both sides. I like to have a spreadsheet, and I have the inventory and appraisement on a spreadsheet that I prepare ahead of time, and I like to put it on a thumb drive. So I put it on my hard drive, I bring my computer, I put it on a thumb drive, because sometimes the printing is the problem. So if you have a thumb drive and you can pass that thumb drive back and forth, it's easier to get things printed. So that's a good tip, is always have a thumb drive with you. And I send the client a mediation preparation letter. And I started doing this because there's some things that it's good for the client to know in advance, and there's so much information that they have to take in during the day of mediation that if they can look at some things in advance, it's a little less stressful for them. And we all know that there are mediation settlement agreements that we sign, and that's not going to be the full language that ends up in the decree, but there's some standard language that typically will end up in the decree. And often the mediated settlement agreements will say, if we have an argument, we're going to use the family practice manual. So I just started printing off parts of the family practice manual that are likely to be that language that's referenced, so my client can look at it in advance. And typical language is the health insurance language. You know, we say one line in the mediated settlement agreement that husband or wife or mom or dad are going to pay for insurance for the child, and then it turns into 3 pages, 4 pages of health insurance language. So I include that. I include the standard possession order, and you might not end up with a standard possession order, but perhaps you'll end up with standard holidays or standard summer. And the summer is complicated, as we've all seen. So if people can look at that ahead of time, maybe the standard travel language, the terms and conditions, anything you can think of that you end up with, the passport language, that you end up with in your decrees that your client could look over, I think it just helps them to be a little bit more prepared, no surprises, and it also helps protect you. So your client doesn't say, well, you didn't tell me that when it said the standard language it was going to be this, and I hate this language. So it helps them to have that conversation with you in advance. So I call that the client mediation prep letter, and we have a sample of it for you in the template. And then I like to do a position statement, and I'll tell you what I mean by a position statement. It's basically telling the mediator a little thumbnail of the sketch from our perspective and what we think should happen. And we all have always done that verbally, and we've always told the mediator, okay, here's how I see it. But I started putting that in writing because I think it helps me to prepare myself and to think through the case, and it also helps my client to see what I think our position is. So my client and I are on the same page. So it's just a good preparation tool. So I do it's not lengthy. I don't want it to be lengthy, but it is something that clearly states our position and the history and why we think that our position makes sense. And then I have the client review it in advance. And then if you're way disconnected with your client, you'll figure that out before you get to mediation. And then, of course, I prepare a settlement offer. And your settlement offer, you might decide strategically to send it ahead of mediation or not. And there's a lot of different reasons that go into that decision. Typically, it's good to have sent a settlement offer before mediation. But there might be times when maybe you think something's going to happen in the case before mediation, where you think you're never going to get to mediation, where you don't want to show your hand on something. I don't know. There's things to consider. But typically I send mine in advance, and then when I get to mediation, I say to the mediator, well, we already sent an offer, so now we need a response from them. And then they start on the other side, and it just saves some time in the day. They don't have to understand our offer and convey it. It's already been sent. So that's my typical position, but I do recognize there might be times when I don't do that strategically. And sometimes people will ask me, they've read some book. It's usually a client has read a book, and the book says never give the first offer or always give the first offer. And there's different thinking behind all of that psychologically. So your client might have a feeling about always or never, but typically, I have not found that there's any difference if I make the first offer or the second offer. I don't think it makes a huge difference. The advantage of sending the first offer and providing the spreadsheet is maybe you've set the framework. But I think you can set the framework also by sending the second offer. Sometimes, because I bring the spreadsheet and I bring the thumb drive, the mediator will work off of my spreadsheet all day. I do think there's an advantage to that. So it kind of goes back to being the most prepared. If they'll work off my spreadsheet all day, I know that everything's on there, nothing's been forgotten because I created it. If I'm working off the other party's spreadsheet, I have to double check the spreadsheet, make sure that the formulas are working, that the numbers are adding, and that they've included everything. So I much prefer to work off of my spreadsheet. And I like to send, when I'm organized enough to do it, my packet to the mediator in advance. And you can even send that spreadsheet on the thumb drive in advance to the mediator. So I think you heighten your chance that then they're going to be working off of yours. There are some mediators that won't work off of anyone's. They kind of create their own. But then you need to be double checking against your own. At least you have yours to double check against to make sure everything that you've thought about is included. And don't trust your spreadsheet or anyone else's that the formulas are working and that it's adding properly without double checking it. You know, it's all, the computer can only deal with the information that has been input into the computer. So the formula, somebody could have messed it up when they were entering that last number for you. And you can't trust that it's always adding. So I just do, get out a trusty calculator. We all have them on our phones now. And just add up all the numbers in an old-fashioned way and make sure it's adding properly, so that you don't find out later that due to an error in a formula or an error in the spreadsheet, a line was added, that line isn't adding. It's very easy to mess them up. They're very handy because once you know your spreadsheet is solid, you can make changes during the day and it will quickly make the changes for you. But you need to make sure your base is solid, and I've learned from experience that they're easy to mess up. So just do a basic double check of that. Okay, I like to schedule a call or meeting with the client ahead. So you don't want your client they're so stressed out. It's a very stressful time, and mediation is a big deal, and it might be their last, hoorah of their case. So you need to prepare them for mediation and have a meeting, whether it's on the phone or in person, to tell them what is mediation. Unless they've been in another context, a business context, or another family law matter, they're not even going to know what it is. So you need to educate them the very basics and calm them down and tell them, that we're going to have our offer, we're solid, we understand, we can kick the mediator out anytime during the day and talk privately. And also help them to start opening their mind to settlement. That they don't want to just be rigid in the sand with it's their way or that's the only way. Because a lot of them feel that way, and they're almost protecting themselves by feeling that way. That I have to stand my ground on this or I'm going to be run over. So we can assure them we're not going to let them get run over, but they're going to have to be more flexible, because if both of them came in, that was their only position, we'll never settle. And there's often a lot of settlement ground that would be acceptable to your client and to the other side between their two rigid positions if they just allow us to explore that. So we have to start preparing the client for that mentally, for going through this exercise. And information puts people at ease. So if they just understand how it's going to work, and they can communicate their fears, and you can tell them, no, that's not going to happen, or yes, you do need to be worried about that, whatever. Information empowers people. So you definitely want to have time for that. I think sometimes when we get busy, we think, oh, there's going to be all this dead time, I'll just explain it to them while we're there. Well, then they're already going to not sleep the night before. Well, then they're really not going to sleep the night before. So I would dedicate a little bit of time ahead to get them ready for that mediation session. And simple things that we have in here, reminders that you can assign to your staff, is email directions to the mediator's office or wherever the mediation is going to be to the client. It helps if they know how to get there. And to the lawyer. Helps if I know how to get there. And email the client in advance. We have a little action reminder here that they need to pay the mediator. Because sometimes that isn't communicated to the client. They don't show up with a check. You don't have a check. And now the mediator doesn't know what to do. So whatever that mediator's fees or requirements are, some of them require the lawyer to pay, and then the client needs to pay you so you can pay the mediator. Some require the client to pay, but they all require that they be paid. So you want to be clear about that in advance. Then we have in the template, once mediation is complete. So somebody needs to file the mediated settlement agreement. And now with e-filing and fax filing, everything is so easy to file. But you don't want to forget to do it, because it's going to be more binding once it's filed. So you definitely want to make sure that that gets filed, and this is just an easy way to assign that. And then you want to make sure that your staff tells the court that we have settled and removes the trial setting. It would seem that when they got your settlement agreement, that would cue the court that you were not coming to trial. But it doesn't work that way. They're not necessarily aware. They're not reviewing every piece of paper, of course, that comes in. So they just really appreciate it as a courtesy if you send an email to the coordinator and say, hey, we've settled our case, we don't need that trial date, so that we can keep our courts productive and they can do something else that day. And then provide your client and opposing counsel with a file marked copy of the MSA. So if you're the one filing it, when you get your file marked back, this is just an easy, simple reminder of that. So with all of these tips and other tips that you can add to your template, we have the mediation template.